This is where it gets confusing, and this is where people say, "But where did that $100,000 come from? Where did it come from?" Whoa, wait a minute. Hi, Jeff Marsachi, the plain English attorney, and today we are going to talk about when unequal distributions and allocations is actually fair. So there seems to be this mentality that, oh, we've got to treat all kids equally. That doesn't have to be the case. And really, what is fair isn't objective when you're talking about an estate plan. It's what the clients want. So when my clients want to do something in terms of spreading out their wealth and their trust estate among their kids, it does not have to be equal if they think it's more fair or more equitable to leave more money to someone else. Now, how is this accomplished? Because there are a couple of different situations. The biggest one that I hear a lot more often is how one child, they spent a lot more on their education than the other children. All right, so in the estate plan, this is kind of their way of making it up to the other kids by giving them a bigger percentage. Nice and simple. One thing that I often tell my clients not to do is try to explain it in the estate plan. Just go ahead and do it, and then tell them or tell the trustee, look, this isn't going to be equal, but here are our reasons why. Excuse me. Well, why wouldn't you just kind of put that into the trust document? Well, because it really does open a door as well. That's not really true. I gave, they may have given me more money for education, but I gave them a lot more, and therefore you don't even need to bring that argument into it. These are the percentages that you've decided on for your estate. That's it. Explaining it in the legal document just opens it up to more potential challenges. Explaining it informally gives a reason and a rationale, but not a way to attack it in the documents.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
So yeah, there's education. There's also, this particular child didn't have as good a career as the other children, and we had to bail them out financially several times. Okay, so they can figure out exactly what that is. In addition to just doing unequal percentages, they can also kind of give lump sum payments up front to the other kids that kind of make up for it before afterwards treating everything equally. Well, really, what's the difference doing percentages or doing these dollar amounts? Well, it's because it actually looks different for a lot of people, especially the beneficiaries. Let's just say that there were 3 kids, 2 of them got full ride scholarships, and the third child they spent $200,000 on for their education. So if they said, well, roughly, let's just then make it 35% and 35%, and the child that they spent the money on gets 30%. Well, okay, that's percentages. Things could fluctuate over time, but you're looking at it and you're in your mind, you're saying, well, that's not equal. What if instead up front they said, okay, this child gets 200,000 and this child gets 200,000, and the explanation you give the trustee is, well, it's because we spent 200,000 on the third's education. They're not getting that first initial 200,000 each. And then everything's equal, right? Psychologically, that actually makes things a little bit easier to stomach by it being unequal, but not actually saying so. It's after those kind of off the top distributions are handled, it's then again equal. It also kind of has the value, the merit of just having the dollar amounts that are associated with the education coming off the top. You don't have to say it's because of that, but then it's flexible. Your estate could be grown substantially by the time you pass on, or it could have dwindled more, but those off the top numbers are equating with what you spent on that other child's education. So those are some reasons why you may not want to actually treat the kids equally. Treating them unequally is actually more fair and equitable. But what about gifts, loans, and advances? All right. Gifts, loans, and advances is a topic that recently came up with some clients and trying to figure things out because, okay, they gave some money that was supposed to be a loan. They want to treat it as an advance. If they pay money back, then okay, it reduces whatever that amount is. But, well, how do we treat this? And what's the difference among the three? So, really, the best way that I have found to handle this is doing it with math and examples. And so, we're going to jump into that right now. So, with the example, John and Jane Doe, parents, three children are James Doe, Jennifer Doe, and Jefferson Doe. And John and Jane Doe provided Jefferson Doe $100,000 10 years before the second of them passes on. Their net trust estate, without considering that $100,000 to Jefferson, was $3 million. So, how is this treated differently if the $100,000 is a gift, an advance on the inheritance, or a loan? Okay, so this is where we're going to jump into the numbers of it and see how things are treated differently because they are differently, especially if there is interest on the loan. Right, so let's first use it as a gift. If it was $3 million in the net trust estate, that $100,000 was considered a gift. Yep, they just gave it to Jefferson. No issues, no problems. The trust estate is divided as $1 million each. Okay, so Jefferson got an extra $100,000 10 years ago. It's a gift. How do you actually determine this, though? Was it a gift? Was it a loan? Was it an advance on the inheritance? One of the things that we do in the trust that we put together is it's all laid out. You have a Schedule A that has, here are the amounts, so they could put in that $100,000 and simply put that it was a gift, and that's it. If it's not considered a gift, okay, they'll put it as an advance or as a loan. If there's a loan, they should put something in there about the interest. The thing is, I'm pretty sure once they've passed on that James, Jennifer, and Jefferson Doe are going to look at that $100,000 very differently. Jefferson's going to say it's a gift. His siblings are going to say, oh, no, 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 that was a loan and we have to take that money out. By putting it in the schedule, it's done, it's taken care of, and it's clearly identified. So let's go on to the next one and see what happens if it is an advance. Hey, we're giving you some of your inheritance early. How do we calculate that? All right, so if there's $3 million in the net trust estate, $100,000 advance on the estate from Jefferson is added back into the trust calculations, even though the money isn't actually returned to the trust. This is where it gets confusing, and this is where people say, but where did that $100,000 come from? Where did it come from? Whoa, wait a minute. You have to think about it. It was an advance. So if they hadn't given that $100,000 to Jefferson, their net estate wouldn't be $3 million. It would have been $3.1 million. So if he got that advance, that's the only reason it's $3 million instead of $3.1 million. So you add back in what the advance to Jefferson was to get to what the true estate would have been if he hadn't gotten that early. So now you divide that 3.1 million equally. Excuse me. You divide that 3.1 million equally among James, Jennifer, and Jefferson. So each gets 1,033,333 and 33 cents. And okay, you give the extra penny to the trustee for figuring this out. Then you subtract out that 100,000 that Jefferson already received, meaning the trust estate is divided as James Doe gets that full 1,033,333 and 33 cents. Jennifer gets that same amount, and Jefferson gets $933,333.33. So it's not that James gets 1 million, Jennifer gets 1 million, Jefferson, oh, well, he already got 100,000. We're taking out the 100,000. He gets 900,000. What that ends up doing is leaving 100,000 still in the trust. No, so you got to add it back in, divide it by the beneficiaries, and then subtract it from the calculations because, well, Jefferson already got it. So again, a little bit confusing for some of my clients, but that's how you compute the advances. All right, so let's take a look at what if it's a loan and there's actually interest. Right, so loans are conceptually treated differently than advances, although the math often comes out the same if there's no interest on the unrepaid loan. Let's say there was 5% compound interest, compounded annually, on the $100,000. So now there is a different result. If there was no interest, it would have been exactly the same type of math as an advance. But $3 million in the net trust estate, that $100,000 loan from the trust estate to Jefferson was never paid back, having that compound interest. So when you add back in the amount that should have been paid back by Jefferson, that amount that should have been paid back is $162,889.46. So now you're dividing 3,162,899.46 equally among James, Jennifer, and Jefferson. So they're each getting a little bit more than the previous example, 1,054,296.48. And then for Jefferson, you subtract back out that amount he should have paid back to the trust. So James is getting that full 1,054,296.48. Jennifer gets the same amount. Jefferson now is only getting $891,407.03. So those numbers do come out quite differently when you're adding the interest. So you need to take a look at all of that when it's a loan. If there was actually a documented loan with interest and none of it was ever paid back, and you record it appropriately in the trust that, hey, here's this loan, then it's got to come out. Well, what if you don't put it into something like a Schedule A? Well, then the trustee has to try to collect the debt from Jefferson. And you can run through those calculations as well. But again, anytime you've got that schedule and you can be very clear about whether something is a gift, an advance, or a loan, great. If you're going to do a loan and you're going to have interest, you really should have it in the form of a legal contract according to your state's laws. So that's talking about gifts, loans, and advances and the difference between them. There's another big one that we sometimes see when unequal is fair, and that's when you end up with blended families. So let's just say John Doe, James and Jennifer, James was his child. Jane Doe, oh, we have Jennifer and whatever her previous name was instead of Jennifer Doe. And then together they had Jefferson. Well, Is it just fair to divide everything equally among all three? A lot of my clients do look at it that way. In their mind, it's like we love all of our kids equally. Doesn't matter who has other parents and biological and all of that stuff. Doesn't matter. But there's also that strong possibility that James may be inheriting something from his mother's side of the family, biological mother. For Jennifer, there may be the father, her birth father's family. She may be getting some inheritance there. Jefferson doesn't have that because John and Jane Doe are the two parents. So sometimes the way this gets divided up is we use it in terms of shares. So each child gets one share among however many parents they have. And we're assuming no adoption or any of that stuff. It's step parents. All right, so James gets one share because his parent is John Doe. Jennifer gets one share because Jane Doe is her parent. Jefferson gets two shares because both John and Jane Doe are his parents. So that's four shares. So Jefferson would get 50%, James would get 25, and Jennifer would get 25. And really, the whole rationale is there's another quote side of the family that they could be inheriting from that Jefferson isn't getting, and that's why they did it this way. The other thing I often tell my clients is, look, if you need to blame someone, blame the attorney. I can explain all of this if things blow up, that this is how we did the math and this is what they wanted to do. So I hope you found that information useful, and I hope you realize the biggest point of this is just because it's not equal doesn't mean it's not fair. And what is fair is entirely up to my clients who are creating their estate plan. That's the only judgment on fair that really matters. So, as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.